Afternoon. Thank you, Dean Eileen. As the prompt just came up, this CLE is being recorded today. My name is Sarah Washington, for those that do not know me, and I'm the president of the UB Law Alumni Association's Gold Group. Thank you all for taking the time to attend today's CLE presentation entitled Vaccine Mandates, Welfare Benefits Plans, and Incentives. Oh my. This is one in a series of many virtual programs the Law Alumni Association and Gold Group is hosting as a service for our alumni and our law students, as well as community members. If you are interested in attending other upcoming webinars and CLEs, you can register online on the UB Law School website, law.buffalo.edu/alumni events. You can also listen to past CLEs and other webinar recordings at no charge on our new alumni education webpage, also located on the law school's website. To get discounts and select free 1-hour CLEs, please consider becoming a dues-paying member or a lifetime member of the UB Law Alumni Association. You can join at www.law.buffalo.edu/alumni/membership. You can also contact the office, and I'm sure they would be more than happy to invoice you. Finally, I'd like to thank the Gold Group sponsors who have helped underwrite the costs associated with our events this year. Chicago Title, Council Press, Equitable Advisors, Jack Hunt and Associates, and Precision Resolution LLC, Paramount Settlement Planning LLC. Now, a few brief administrative points. You will be muted during the course of the presentation. Please do not unmute yourself so that we can reduce feedback. If you have a question at any time, please only use the chat function, which has been enabled, and we will try to address the questions at the end of today's CLE. At some point during the CLE, the course code will be announced, and it will also be placed in the chat. Please be sure to catch it, as you will need to put this on the online attorney verification form that was included on the registration page. The form is required in order for you to obtain CLE credit. Please also return the program evaluation form found on that page. I'll now turn it over to Emily.
Hello, my name is Emily Rudroff. I'm a graduate of the law school and co-chair of the education committee for this year's Gold Group. It's my pleasure to introduce our speaker, Melanie Beardsley, who is a graduate of the class of 2010 and a partner at Webster Zaney LLP. She is a partner in the firm and a member of the labor and employment education practice groups. Before her return to private practice in 2019, Ms. Beardsley worked as a senior labor relations specialist and counsel for the Cattaraugus Allegheny BOCES. She works with school districts, BOCES, municipal entities, and private sector organizations in a wide range of labor and employment matters. Her experience includes a multitude of student matters, special education claims, contract negotiations, grievances, and arbitrations, development of workplace policies, internal investigation, charges of discrimination, harassment, and retaliation, and day-to-day counseling regarding personnel matters. Ms. Beardsley represents clients before the New York State Division of Human Rights, the Equal Employment Opportunity Commission, the New York State Public Employment Relations Board, and the National Labor Relations Board. Ms. Beardsley is a graduate of the State University of New York at Buffalo Law School, University of Maryland's University College, and Dickinson College. She is a member of the New York State Association of School Attorneys, Council of School Attorneys, Erie County Bar Association, and New York State Management Advocates for School Labor Affairs. Ms. Beardsley has been repeatedly selected for inclusion in Super Lawyers Magazine as a rising star. She lives in East Aurora and actively volunteers with the MS Society. And I'm going to turn it over to Melanie.
Thanks so much, Emily. And thanks to the UB Law Alumni Association and the Gold Group, in particular, Megan Corcoran and Earl Cantwell, who reached out to me for this presentation. I appreciate the opportunity to speak on this ever-changing topic right now. So because it is ever-changing, I may not have all of the answers at this time, and it remains to be seen, some of the requirements that we're going to talk about today have not been solidified. So with that being said, as Sarah mentioned at the beginning of the presentation, please feel free to put in questions in the chat box. I'm happy to answer them if I can, or if for some reason I can't, to look into it and get back to you throughout this presentation. So without further ado, let's talk about what I plan to cover today during today's 1-hour presentation. I want to just go over right now where we stand in New York State in particular with the current mandated vaccination requirements. There are certain employers that are required to have vaccine requirements for their workforce at this time, and we are currently waiting for additional guidance and requirements that are going to be coming down from the federal government, OSHA in particular, as it relates to certain workforces. So we're going to go through that initially. But I think the more important question is for everybody else, for all the other workforces, for all the other workplaces, and for all the other employees, if we really want to encourage vaccination options, what are we permitted to do? What might we think about that? And what are the options that employers can consider? And what are some of the questions and concerns that they may receive from employees or that employees may have? And I think are really important for employers to be able to guide their employees and answer their employees correctly. So that's really the second part of the presentation today that I want to focus on, are what are those practical options, and legally, what are we allowed to do? What are we not allowed to do? And how should we be handling employee requests and employee questions regarding those? So the current mandates as they stand right now, there is a federal executive order which covers federal employees, including federal contractors, right? That right now is in place. However, the timeline has not yet hit for all federal employees to be vaccinated. That timeline, as you'll see on this chart, will hit sometime in late November, just before Thanksgiving. But what it really means is that all federal employees are expected to be vaccinated no later than November 8th, 2021. New York State healthcare employees, most of you have probably seen this in the news and the media. There is a Department of Health emergency regulation through OSHA that requires, again, all of the folks that are listed in that section, staff at hospitals, long-term care facilities, nursing homes, et cetera, to be vaccinated, and that they must be vaccinated no later than September 27th, 2021. So that time frame has already passed. I know that we've seen in many, many scenarios, folks who have decided to not comply with those vaccination requirements, and healthcare employers having the difficult decision of what do they do with those employees. Do they put them on leave to see if the employee decides to change their mind? Do they simply seek the separation of the employee, or how do they handle that? With New York State school districts, we also have an emergency regulation and a determination from the Department of Health Commissioner and the Commissioner of Education. All teachers, administrators, and school employees are supposed to be vaccinated or subject to weekly testing. So the way that the regulation and determination is actually written is that it requires testing on a weekly basis, but the employee can opt out of that testing if they are vaccinated. So the default is that everyone's subject to the weekly testing unless the person provides a vaccination document showing that they have been fully vaccinated. If they decide not to show that document or decide that they're not going to get vaccinated, then they're going to be subject to this weekly testing to ensure that they are not positive, and then of course going into a school. There is a different requirement for New York City teachers and employees, and I just wanted to mention that at the bottom of the chart there. They are actually required to be vaccinated, very similar to the healthcare employees. That vaccination requirement has not spread over to the remaining New York school districts, but is something that is solely for New York City, and it is a regulation that was required by the New York City Department of Education, which oversees all New York City schools, versus in the rest of New York State, the Commissioner of Education and Department of Health, who really oversee schools as it relates to those COVID issues. So that's where we're at right now in New York State with vaccine mandates. The private employers, right now, we know that on September 9th, President Biden came out and issued a mandate that was going to expand the requirement for vaccines that started with the healthcare employees, expand that to all employees or employers who have 100 or more employees. And how that really occurred was that there was a mandate given to OSHA to provide an emergency temporary standard. And there is no timeline by which they have to provide that, but they are expected to develop an emergency temporary standard that will now apply to all employers with 100 or more employees. We don't know when that may come out. OSHA made a statement in about mid-September saying that they were working on the ETS and they expected it to come out in the coming weeks. I've seen other experts really estimate that it's probably going to be somewhere between 30 and 60 days from the initial statement made by President Biden on September 9th. So maybe we're looking at the very beginning of November. We're just not sure right now. And we're also not sure exactly what that ETS may say. We do know, for example, though, who it may apply to with the 100 or plus employees. They're looking at 100 employees being company-wide, which I think is very important for employers to know. It's not just going to be 100 or more employees at a particular location or facility. So it's going to be company-wide, looking at whether or not the organization has 100 or more employees overall. Then they will fall under this new ETS that is going to come out from OSHA, which again remains to be seen. So stay tuned to that. We'll see what happens with the agency and what sort of restrictions and expectations they put in place for employers and employees to be aware of. With all of these mandates, there are some exemptions that, of course, employees can offer up to their employers, and that employers should be very well aware of if an employee does come and ask questions or have a particular request for an exemption. Most employers, and I say most employers because not all employers are covered by Title VII and the ADA, but most employers are going to be covered by Title VII and the ADA. And so if an employee comes and says that they need a reasonable accommodation and they cannot be vaccinated due to some sort of disability, there are requirements that the employer has to go through to determine whether or not there can be an accommodation for that particular individual. Similarly, if their employee has a sincerely held religious belief set forth under Title VII, we may have an obligation to exempt the person from the vaccination. Now, this may come into play with healthcare workers, for example, because it's a vaccination requirement. If there is a vaccination or testing requirement, I think the conversation changes a little bit. So for example, for public sector employers, school districts, they have, as I said before, a default where you are tested on a weekly basis, but you can opt out if you are vaccinated and require proof of vaccination. So the question is whether or not somebody actually needs a reasonable accommodation from being tested. And there's multiple different types of tests that can now be performed that are consistent with the Department of Health standards that have set forth for this weekly testing. Some of them are nasal swabs, some of them are saliva tests now. And I think it will be very difficult for an employee to assert that he or she is unable to actually subject themselves to a nasal swab or a saliva test for some sort of disability. I don't want to say that it could never happen because we never like to talk in complete, 100% for sure it could happen or could not happen. But I think it would be very difficult for an employee to establish that they absolutely cannot have a swab of their nasal passage or to be able to undergo a saliva test. The same thing goes for the sincerely held religious belief. If we're talking about the standard of vaccination or testing, not solely vaccination only with no option to test instead of being vaccinated. Again, I think it would be difficult, not saying it would be one way or another 100% set in stone, but I think it would be difficult for an employee to say that a sincerely held religious belief prevents them again from providing a saliva test or a nasal passage. And we'll talk about that that interactive process that the employers have to go through when an employee comes and has questions or raises an issue saying, I need something, I need an accommodation, or my religious beliefs prevent me from actually complying with the mandates and directives that you're sending out and you're telling me that I have to follow. So can we mandate the vaccine if we don't fall under one of those previous categories where we have a law or a Department of Health order in place saying that we have to? The EEOC says, yes, you actually can. Again, if it is a qualification or safety related standard that's applied to all employees, and if it's job related and consistent with business necessity. So where would this come into play? I think it would come into play when you have a workforce, for example, that does not have much, if any, in-person, face-to-face interactions between coworkers or between customers or clients that they work with. So for example, if you have a workforce that you have now permitted to work from home because it was the pandemic and everybody was working from home, and the employer has decided this actually works really well for us. We don't need to have people come into the office. Everybody can be remote. Then if nobody is interacting in person with one another, I think it would be very difficult for an employer to say, mandating a vaccine with the workforce that we've decided to set up in a work for home or virtual environment that we've decided to set up is then a vaccine mandate would be job related and consistent with business necessity. I think that would be a very tough argument for an employer to put forth. Now, if we're talking about a grocery store, a retail workforce, where we have customers and clients coming in and coming out, and interaction between employees in person, no matter what the situation is, I think that type of scenario is going to be very easy for the employer to say and to establish that a vaccine mandate here is going to be a qualification or safety related standard that we're going to implement. And it is job related and consistent with business necessity. We want to protect our employees. We want to protect the clients and customers that are coming into our organization right now. And so we're going to say that we're going to mandate the vaccine for this particular situation. Can we then require compliance by our employees who may be non-compliant? Arguably, yes. We could take the position, an employer could take the position that the employee, if they were to be non-compliant and not get vaccinated, and I should say this is entirely separate from an employee who's bringing up an accommodation request, but we could absolutely say that the employee would pose a direct threat to the safety or health of the employees or others in the workplace. And the others are the customers, the clients, the folks that they're interacting with on a day-to-day basis. And you see here on this particular slide, I even put down the direct threat and the definition of that the EEOC looks at. And you'll notice the EEOC in their regulations weaves in the idea of it also, this direct threat cannot be eliminated or reduced by some sort of reasonable accommodation. Okay, so if the employee absolutely has to come to work and has to have face-to-face direct contact with other employees or other clients or customers, and there's no way to eliminate or reduce that contact in any way, then we're going to be in a very difficult situation in talking with that particular employee or group of employees, if it's a particular position that multiple employees hold, to say, gosh, I really don't see how this is not a direct threat here. And if the employer is going to decide to mandate that, I think they're likely going to be on a reasonable ground to say, here's why we're doing it, and here's why we believe we're doing this in compliance with the EEOC guidelines and the standards. So if we need to go down the path of looking at whether or not it's a direct threat assessment, it's in a gray area, we're really not sure. I have on this particular slide the 4 things that you really want to look at, and weaving it into, if we do have employees, a few or many, that are asking for reasonable accommodations to the vaccine mandate overall, you really want to look at, well, is this reasonable accommodation? Would it reduce or eliminate the direct threat? And again, I think in this scenario, if we're talking about close contact, in-person interactions between employees all the time or employees and clients or customers, it's going to be difficult to say that a reasonable accommodation where the person doesn't have to be there would actually eliminate that. Because if we're talking about a clerk or a cashier in a grocery store, we can't let them work from home. We can't do that. They have to be there. They have to be in person. So are there other things that we could do to reduce and or eliminate the threat? Possibly. There's been lots of research so far, and I'm sure there will be more about whether or not the barriers that we've seen now in the last 18 months are helpful or not helpful. We've seen studies and research, and I expect to see more research about social distancing and masks. So those are the conversations that I think an employer needs to be having overall in determining whether or not we can provide any accommodations that's going to reduce or eliminate the direct threat that we're concerned about if we're thinking about a vaccine mandate here, and thinking about whether or not we're going to impose this, expecting that some employees might question or have concerns or frankly be non-compliant with this and how we're going to handle that. One of the final questions that you typically want to look at in determining whether or not there should be a reasonable accommodation provided is whether or not the reasonable accommodation imposes an undue hardship. And I'll share very briefly that an undue hardship, at least with respect to ADA accommodations, undue hardship is a very, very high standard to meet. And we'll talk about that a little bit later. With the religious standard, it's actually slightly different under Title VII. So if you have an employee who comes to you and says, I do want an exemption from the vaccine mandate, if an employer decides to impose a vaccine mandate, these are the questions that you really want to look at and ask. Does the employee actually have a disability that warrants the exemption and that covers them under the ADA? I can tell you right now that with respect to the testing and vaccine requirements that we've had, at least in school districts, with this so far, I have seen a number of requests for accommodations to classrooms and to buildings, not necessarily to be exempt from the vaccine mandate or testing requirements. And oftentimes when we start to engage in the interactive process, we have found from time to time that many people, frankly, are scared and they're concerned about the spread of COVID, catching COVID. They're scared about passing COVID on to other employees and other colleagues and students in the building. And that fear in and of itself is not necessarily a disability. And it can be a very difficult conversation between employees and employers to say, I don't think that you in fact have a disability under the ADA. But I think it's a very, very important conversation for employers to have with each employee when they come to them with these questions, and to handle those questions in that process with empathy and understanding is something that I've always been advising clients on, because we're in a really tough situation right now, and the world is very divisive right now. And many employees are coming with viable questions, reasonable questions, a lot of fear, and sometimes very emotionally charged. So this interactive process can be very taxing for employers, but it's really, really important that employers go through the full process and understand, does the employee in fact have a disability? Is there an accommodation that I, the employer, can provide that would permit them to perform their essential job functions? Or would any reasonable accommodation we can talk about impose an undue hardship? And again, as I said before, an undue hardship is really a pretty high standard when we're talking about ADA accommodations. And so I have here the full definition of it in thinking about it. And it really requires significant difficulty and expense when you're considering all 5 of those factors. Significant, not just some, but significant difficulty and expense. And again, that can be very hard for employers to say, oh, I just don't want to pay for XYZ additional equipment for the particular employee. It's usually not that easy. I want to really talk about religious exemptions. Again, employees who may decide and come to you to say, listen, I'm not going to get vaccinated. It's against my religious beliefs. And what do you do with that type of information? And really, I put up here the standard and the questions that you should be asking when an employee brings a question or a concern like that to your attention. You typically should assume that the request is based on the person's sincerely held religious belief. And then you can ask, is there an objective basis for me questioning the religious nature or the sincerity of that belief or practice? And if the answer to that question is yes, you're permitted to ask for supplemental information from the employee. So I have here on this particular slide additional factors that employers may be considering in asking employees when they bring a request for an exemption based on a religious belief to their attention. You know, has the employee behaved in a manner that's inconsistent with this professed belief before? Is this accommodation sought for a secular reason? Is the timing suspect? Has the employer otherwise sought to believe that the accommodation is not sought for religious reasons? I'm sure you can see with these particular factors, this can lead to a whole host of conversations and questions to the employee. I have seen employees sort of shift their explanations from time to time when they unfortunately don't get the answer that they desired from the employer, from one request to be exempt from a particular mandate, not necessarily a vaccine mandate too, but a particular mandate or explanation. And then they move to another explanation, such as a religious exemption. In those scenarios, I've argued that, well, hang on a minute, the timing of this particular request is a bit suspect. You didn't get the answer you wanted the first time around with your first argument. So now you're trying something new, and we want to make sure we go through the process, excuse me, and understand whether or not this is truly a request for a religious exemption. I will also share with you that it really is not something where the employer can demand or require a particular letter or note from a religious organization to support the employee's belief. It is something that the employee can certainly provide on their own. I've also seen and read up on some recent articles where certain employers, again, we're typically seeing this in the healthcare field, certain employers are receiving religious requests, exemption requests from employees. And some of the basis for that is how the vaccine has been developed, how certain fetal cells have been used to develop that. And in certain scenarios, I have seen employers, and certainly have seen this in the media too, where employers have taken a fairly firm stance to talk to employees about that, to say, well, have you used other medications that were developed from the same type of science and cells? For example, Tylenol, Motrin, different things like that, to again speak with the employee and take the position, rightly or wrongly, take the position that, wait a second, you're trying to actually use only a little bit of this information in this religious exemption to say that you don't want to be subject to this particular vaccine mandate for this particular reason, when in fact you have used other medications such as headache medicine, which is developed from the same type of cells. That's a really in-depth factual analysis that I think some healthcare employers have been looking at because they have the expertise to do so. I don't think that all employers will have all of that information to have that level of a conversation with employees, but I do think it is important for employees and employers to know that that's the type of conversation that could happen between an employer and an employee in this interactive process, and to be well aware of what it requires, and that it's not just a checkbox that an employer has to accept information or documentation from an employee to give the religious exemption in this scenario. So again, similar to the medical exemptions, with religious exemptions, you ask the question, are there reasonable accommodations available to provide the employee? And we must provide the reasonable accommodation to the mandate directive requirement unless it poses an undue hardship. Now, the definition of an undue hardship under the religious exemptions is a little different. I had previously on the slides the undue hardship standard for a medical exemption. As you can see here with religious exemptions, it's lower. The accommodation simply requires more than a de minimis cost. That could constitute an undue hardship. Whereas with the medical exemptions you saw, it had to be of a significant difficulty or cost for the employer to then warrant an undue hardship with the 5 factors that were listed under there. So for a religious exemption, the employer, in my opinion, certainly has a bit more leeway to focus on undue hardship if it wants to do that. With an ADA accommodation, I think it's much more difficult to say that some sort of an accommodation in all likelihood would be an undue hardship. But those are the conversations and considerations that employees should be aware of and employers should be thinking about when they're going through this interactive process.
Melanie, can I pause you for 1 second to give the code, the verification code for today's CLE? The code is the word SAFE, SAFE, SAFE. It's also been posted in the chat. Thank you.
Thanks, Sarah. So that's perfect timing because now for the rest of the conversation, we're really going to focus on voluntary vaccine programs, incentivizing employees to become vaccinated, and options that employers can have and should be considering when they're thinking about that. So can employers offer a voluntary vaccine program to employees? Yes, absolutely. Employees can choose to get the COVID-19 vaccine. However, if it's going to be voluntary, employers, of course, are not going to be able to take any adverse action against an employee for refusing to participate in that program. All medical information that the employer receives should be maintained confidentially, and pre-vaccination screening questions are going to be permissible, but again, it has to be voluntary and has to be in the employee's decision to answer the questions voluntarily. Otherwise, it could be seen as a disability-related question. So you want to be concerned about voluntary vaccination programs, voluntary vaccination programs. The EEOC said in that instance, if you're not offering the voluntary vaccination program to all, why not? And the federal agency has said, we will look into situations where there's a decision to offer it to one workforce or one portion of a workforce versus another, in deciding is there a discriminatory reason for that decision to offer it only to a limited number of your employees. Now, if the decision is based on a non-discriminatory factor, such as we're going to offer it up to everybody who is required to come into work and physically report to work, I think if that's the standard that's being offered, in that instance, in all likelihood, you're not going to run into a discriminatory issue there, because you're really focusing on offering up that program to employees who are going to have, again, in-person, face-to-face contact, either with one another or the clients or customers that the employer is serving. So when you're thinking about, do we offer it at all? Do we offer it to a limited number? Those are the things that employers should be considering. Can an employer offer incentives? This question and this conversation is a little bit more in depth for employers to consider. Yes, they can offer an incentive to provide COVID-19 vaccination paperwork. Now, if the employer is simply asking employees if they want to voluntarily provide vaccination paperwork and they can provide an incentive to that, there is really no limitation on what that incentive can be. And we'll talk about what the incentive might have to be limited to if it's not that type of scenario. So if we're not providing the actual vaccine, if we're not working, and when I say we're, I mean the employer, if the employer is not working with an agent, whether it be an outside medical provider or CVS or Walgreens directly to provide vaccines to their workforce, they're just saying, if you are vaccinated and you'd like to provide us with this vaccination paperwork, we, the employer, are going to give you a $200 gift card, or we're going to give you a bonus in your next check, or we're going to give you XYZ financial benefits, there is really no limit to the incentive that the employer can provide to the employees in that scenario. We are not overseeing, the employer is not overseeing the vaccination of the employees themselves. They are not working with an agent to have employees go to get vaccinated. And again, it's entirely voluntary as to whether or not the employee wants to be vaccinated and provide this information. What about if we are actually going to work with a third party or agency? What happens then? If there is a situation where an employer says, we're going to start working with CVS, we want to provide easy access for our employees to become vaccinated. And if they choose to become vaccinated and they go through this program, we're going to provide them an incentive. Is that appropriate? Is that something employers can do? The answer is yes, but in that scenario, the incentive itself cannot be so substantial that it is coercive. And right now, employers really don't have a good sense from the EEOC, at least, of what that standard of coercive would be. In January 2021, the EEOC issued proposed rules to talk about what was so substantial to be coercive. But in fact, those rules have since been, those proposed rules, excuse me, have since been withdrawn. So we're not really sure. They did talk about it shouldn't be so substantial. It could be something as small as a water bottle, and could be a corresponding gift card of a nominal amount. But again, what would that amount be? Is $50 substantial? Is $100 substantial? We don't really know right now. I guess you could probably tie it to the cost of a water bottle, but I have to tell you, there's some really fancy water bottles out there right now these days, and it could cost, over $50 if you really wanted to stretch it and look at what you could do. So we're not really sure what substantial means, so substantial to be coercive, but what I certainly have recommended to employers is to say, look at what you want to do. And just know that the higher you go up in the financial amount that you want to give employees, the more risk you should associate with that increased financial amount for that incentive that you want to give employees. So that's it. There's going to be some judgment on behalf of the employer as to what they want to do for that particular program and how far they want to go to hopefully determine, do we think that this is so substantial that it's coercive, and then employees feel obligated to undergo the vaccination to receive this incentive or not. So of course, as I said before, we can offer to incentivize employees, and we can offer to have them go through an agent of ours. But again, we have to be concerned about pre-vaccination inquiries. So pre-vaccination inquiries, if we're talking about offering the vaccination directly to employees or working through an agent, are going to be evaluated then as disability-related medical inquiries, and the incentive program and the vaccination inquiries are going to have to comply with the voluntary wellness program regulations. So these are the voluntary wellness program regulations that I have here in the next couple of slides. And it talks about whether or not employers can offer a health program that includes disability-related inquiries or medical exams. So the program has to be voluntary first. And if the program is voluntary, it would meet these 4 standards. Employees don't have to participate. We don't deny coverage under any group health plan or benefit packages if somebody decides not to participate. We don't take any adverse employment action or retaliate against or interfere with an employee's ability to participate or not participate. And we, of course, provide employees with appropriate notice. So again, this is really when employers are looking to work with another organization, an agent, or themselves to essentially provide the vaccination to employees directly versus saying to employees, if you go get the vaccination on your own, bring back the paperwork, you get this incentive. Again, in that scenario, there's really no limitations on incentives or concerns because the only thing that the employer is really getting from the employee in that instance is some sort of proof of vaccination paperwork, which then should be maintained confidentially and separately from other personnel information. It's really all employers have to think about when they're talking about a vaccination incentive, where the person just goes out and gets the vaccination on their own. All of these slides and all of this further conversation right now is really focusing on a vaccination program and a wellness program that the employer is encouraging employees to undergo, where they're working internally or with an agent to provide directly to its employees. So once you undertake that, you undertake additional risk and additional requirements under these voluntary wellness programs. So the notice I have in here under this slide, I think it's just important for employers, if they are considering looking at this potential program, what does that notice actually have to entail? And so I won't go through this entire slide here because you obviously can see it in this instance. What information do we need in this scenario to ask for employees? What do we have to notify employees of? And how do we have to notify them? What about employer incentives for family members? Can employers offer incentives to the employee for the employee's family member to be vaccinated? So can we say, if your immediate family member, your spouse, your kids, your parents, if they get vaccinated, we're going to give you an incentive? Well, EEOC says, no, you cannot offer an incentive to the employee for their family member to be vaccinated. And why? Well, Title II of GINA actually prohibits employers from providing incentives for exchange of genetic information. And this potential arrangement that we're talking about here would require the employer or the agent to ask the family member pre-vaccination medical screening questions. Again, this is a scenario where we are offering, the employer is offering for the family member to be vaccinated through the employer or through an agent of the employer. Again, a CVS, a Walgreens, a medical provider who comes in on site. Think about it in the same way that some employers provide flu shots for their employees, for example, right? I certainly, my husband works for M&T, and I went one year to get my flu shot through M&T because I worked right down the street from him. And I had to fill out paperwork. I was asked a couple questions before I filled out that paperwork. I got my flu shot. I moved on. It's the same type of scenario here that we're talking about with the vaccination requirement. If, for example, an employer decided to hold the same sort of flu shot, except for a vaccine shot scenario, can we provide an incentive to the employee to bring their family members? No. Can we offer this without an incentive? Yes, you can. But again, if you're going to offer an incentive to the employee, you can't do that with family members because you're going to be asking for specific information directly from the family members' the employee's family members, excuse me, and that's going to be a problem under GINA. Can we offer vaccinations? And I know I just addressed this without offering an incentive. Yes, the answer is yes. If we don't require the employee to have their family member get vaccinated, that's fine. If we don't penalize the employee, if their family member decides not to get vaccinated, that's fine. And we have to ensure that all of the medical information obtained from the family member during the screening process is only used for the vaccination and is kept confidential. So again, in the scenario I just went through there, with my spouse's employer, in that scenario, it was a medical provider that came in to give flu shots. All of the documentation stayed with that medical provider. It was maintained confidentially, and the employer, in fact, did not receive any of that documentation. So keeping that separate is going to be really important because it will ensure that there is no potential risk to the employer that we're providing information to the employer, or even, as you see here on the slide, to the employee's manager, supervisor, or others who make employment decisions for the employee about their vaccination status or decision of their family members to not or to get vaccinated. That's really the potential concern that we're talking about here, and what the EEOC is really concerned about, keeping private and confidential. So, can employers offer an incentive for employees to provide proof of family members' vaccinations? Very similar to the original scenario I talked about where there was no ceiling for incentives. You simply say, if your family member has been vaccinated, you can provide me a copy of their vaccination card and we will give you an incentive. In this scenario, yes, that is permissible. Requesting documentation that a family member has been vaccinated is not an unlawful request for genetic information. It doesn't violate GINA. If you go back to the previous slide that I just went through here, where it talks about Title II and GINA, it's really focusing on what is the information that the employer is requesting from the employee. If that information falls under the definition of genetic information, we have an issue. If that information doesn't fall under genetic information, we don't necessarily have an issue here. So in this scenario, requesting vaccination paperwork, there's no disability or pre-screening related questions that are part of that conversation and that request. It's solely information as to whether or not the person is vaccinated. It's not a request for genetic information. Solely showing somebody your vaccine card and whether or not you've gotten Moderna, Pfizer, Johnson & Johnson doesn't give away any of your individual genetic information, and therefore it's not going to fall under GINA or under Title II of GINA. So there's not going to be an issue there. So arguably the employer could expand this program and this offer of an incentive to say, if you're vaccinated and you bring in your vaccination card, you get XYZ incentive. If your family members are vaccinated, up to however many family members, and you bring in their card, you get additional incentives. That is permissible. It is permissible. I haven't frankly seen it, to be honest with you, but it certainly is something that employers can consider if they want to, again, encourage additional individuals that extend beyond just their workforce to be vaccinated. And so there are options there to consider that and to encourage employee vaccination. So group health plans. Let's talk about this for just a minute. Is an incentive a HIPAA health contingent? Is the incentive a HIPAA health contingent wellness program? And this is really looking at, with your group health plan, are you offering an incentive that corresponds with that group health plan? And if yes, your program has to fall under these 5 requirements here. So again, you have to offer the employee an annual opportunity to qualify for the reward. You have to have a maximum reward or penalty that falls within these limitations. It doesn't exceed 30% of the total cost of coverage. It has to be reasonably designed to promote health or prevent disease. It has to make the reward available to all similarly situated individuals and to individuals who qualify by satisfying a reasonable alternative standard. And you have to disclose the availability of the reasonable alternative standard in all plan materials describing the details of the wellness plan. So what 4 and 5 are really talking about is if somebody is unable to, for example, receive the vaccine for a health-related reason. If for some reason they're not able to be vaccinated, pursuant to their doctor's advice, or because they have a medical condition that prevents them from receiving the COVID-19 vaccine. Is this reward that you're giving to people who receive the vaccine, is it still available to that particular person by satisfying a reasonable alternative standard? Can they still receive it, or are they going to be prevented from receiving it because of their medical condition? That can be a problem. That's what 4 and 5 are really trying to address. We have to be able to give a reasonable alternative standard for individuals who might not be able to fulfill that standard because of medical reasons, for example. But again, this is through your group health plan versus a voluntary program that we just talked about previously. That was a lot of talking. I know that was a ton of information. I was hoping to give, a thorough overview of the high level options that employers may have for different ways that they can encourage employees to receive the vaccine. If employers want to start to have conversations about what they want to provide to employees, what they may want to mandate to employees, and what they may want to simply do to encourage employees to the extent that they want to do that. So I'm going to turn it back over to Sarah to the extent that there's questions in the chat box, because I think we've got about 7 or 8 minutes left of the time here, and I wanted to leave a few minutes for that time. I think I can also look at the chat box too, Sarah.
Hi,
Hey,
Melanie. Yeah, I have the questions for you. I can read them out to you.
Great. Oh, thanks, Emily.
Yeah, not a problem. So the first one here is, can employees be made to pay for testing when they request a vaccination exemption?
So what's interesting right now is that there are many options that are available that do not necessarily require payment. Often the County Department of Health will offer testing options. What I will say with that is that they're not the most convenient options. And so they're not terribly convenient from time to time for employees. And so employees will say, well, that's not really convenient for me. I want to be able to go to CVS right around the corner from my house, which is much more convenient, and that costs however much money it costs. If there is a free option, our advice generally has been there's a free option available. And so we're not required to pay for that testing. If you decide to go with the more convenient option, which requires payment, that is your decision. But if there is a free option for employees, we have taken the position that the employer is not required to provide payment to the other options that may be more convenient.
All right. Next question is, how is this impacted by the public statements from many major religious entities that vaccines are not against the respective belief system?
So that's a great question. And typically where that will come into play is if you have an employee who has asserted their sincerely held religious belief and it corresponds with one of the religious statements from that particular sector, if you will. I believe, and I apologize if I'm going to speak out of turn here, but I believe, for example, the Pope has come out and talked about vaccinations and it not being against their religion and encouraging people to get vaccinations. So if an employee comes to you and says, these are my sincerely held religious beliefs, but there's inconsistent information espoused from the leader of that religion, the employer is allowed to present that information to the employee to say, your religious belief and what the leader of your religion or your pastor or the Pope or whomever is saying is actually saying, no, that's not a tenet of that religion. And therefore I have no obligation to comply with that request for a religious exemption. That would be the conversation I would have with that particular employee. What I also say about religious exemptions is that the person's sincerely held religious belief does not have to be part of an organized religious, it doesn't have to be part of organized religion. It can be a sincerely held religious belief of a very small, unknown, offshoot religious sect, if you will. It's pretty expansive. And so when you have situations like those, asking for that supplemental information to understand where the person's belief is coming from can sometimes be helpful. But if there's inconsistent information coming directly from that religious organization saying, we recommend that people get vaccinated, this is not against our religion, I would be taking a pretty firm stance with that particular employee to say, this may be your individual belief, but your religion is actually encouraging your members to be vaccinated. And therefore, it's not a religious belief based on your religion. And therefore, we're going to deny your request for an exemption. That, in all likelihood, is how I would have that conversation with that employee. Again, just as a broad stroke brush without knowing additional specific facts, which could differ on a case-to-case basis.
So this next question kind of relates to that last question, and it is, how does an employer determine that the request is based on the tenets of an acknowledged religion versus the employee's personal, though legitimate beliefs?
So that's tough. It's really hard. Sometimes it's near to impossible to discern from time to time. I will share with you that some of the religious exemption documents that I've received before on behalf of an employer that employees are providing sometimes are pulled directly off the internet and we can't quite tell where they're coming from. And so it's really important, in my opinion, that employers look into the information that's being provided. Now, they also have the opportunity, if they wish, and I think this is really going above and beyond what's required, but it's their discretion to do it, to actually reach out to a leader of the organization to see, is this information in fact accurate or not, as to what this religion these religious beliefs are, and whether or not these religious beliefs are consistent with the religion overall. You could always do that. I think that's going, again, above and beyond what any employer is required to do, because as I said before, the default and the assumption is that the person does in fact hold that sincere religious belief. But the employer is permitted to go down the road and do its own research and speak with, again, leaders of that religion to get additional information to determine whether or not the person is really, if they have another reason for trying to be exempt from the directive or the requirement of the employer. That's really the question that needs to be asked. And trying to ferret that out sometimes can be quite difficult. But doing your research as an employer, speaking with the leader of a church without disclosing the name of the employee, of course, is an option that the employer always has to.
All right. Next question is, we'll do one or two more questions depending on how long it takes. Can employers impose a surcharge on non-vaccinated employees, similar to the smoker surcharge on health insurance benefits?
So when I talked about incentives, what you can do is really have an incentive or a penalty in certain situations. And so I think I had that on one of my screens. I wrote incentive / penalty. You can also work with your health insurance provider and work under the group health plan to determine whether or not there are certain penalties, such as I'm sure most people have seen in the news. I think it was Delta that had some sort of surcharge for unvaccinated employees. That is an option. Those types of scenarios with penalties really run under the same rules as incentives, because the incentive, right, is that you don't lose or aren't charged that benefit. So it could be a penalty or an incentive. And I would point you back to the group health plan bullet points and slides that I had there.
All right. Do you have time for one more? Let's
Sure.
see. This probably isn't too long. Could it instead be treated as a participatory wellness program?
Yeah, it could.
Okay, that was an easy.
Absolutely. Yeah.
And Emily, we had one more.
Oh, there. Okay.
didn't
Oh,
answer
sorry,
that
but
question.
okay. Oh, there it is. Okay, it's a little bit longer. It says we require non-vaxxee to wear masks in the office. Recently, a non-vax person brought a note from their doctor excusing them from wearing a mask due to their asthma. The doctor that signed the note specializes in Botox / fillers and other facial procedures. Is it okay to ask them to get a second opinion from someone with appropriate expertise, like a pulmonologist?
So what I would caution there, because that's really an accommodation question, right? You're requiring them to have a mask because they're unvaccinated. And if they're not wearing a mask and they're unvaccinated, they could pose, quote unquote, a direct threat to other employees and others that are coming into the office, right? That's the analysis that the EEOC goes through. I would question here, and I typically call it a medical certification. I would actually ask additional questions to the employee, and they can go provide those questions to the medical provider. I typically do not require the employee to go to a particular medical provider. It's their decision. I do question it a little bit that somebody who provides fillers is providing information on asthma, right? That doesn't seem to be quite consistent. However, I really usually push the employee to get us information to understand, was the person wearing a mask before? Has their asthmatic situation changed in any way? Are there other things that we can do, such as provide a face shield or other accommodations that would address this? And sometimes the information I get back from the employer is, from the medical provider shows me that the employee just doesn't want to wear a mask all the time because it's uncomfortable. Nobody really wants to wear a mask all the time. We don't want to have to do that. And when you're thinking about accommodations and what we really come back to when we're thinking about accommodations, because I think in this situation, there are other accommodations you could provide probably, is we, the employer, get to pick the accommodation, not the employee. So it doesn't have to just be limited to wearing a mask or not wearing a mask. There's additional information in the interactive process that we can ask for and can determine about how we want to accommodate that particular employee if there are other accommodations, but simply allowing them to be unvaccinated, walking around without a mask, interacting with others, to me sounds like a direct threat under the EEOC guidance and law, and I would have significant concerns about that. So I'd be working directly with that employee to get more information to make sure that we know what we're going to provide them, again, to make sure that they're not a direct threat to others in the realm of safety and wellness.
Thank you so much, Melanie. Our time has now expired. I'd like to once again thank Melanie for all of her time and her insight. I learned a lot that I know I will use at my own company or the company I work. So thank you so much for your insight. You all will be receiving more information about the Gold Groups and the Law Alumni Association's future CLEs. The course code was shared in the chat. Again, the course code is the word SAFE. Please be sure to complete your verification and email that form to Pat Warrington. I also shared a link to access the verification form as well as an evaluation form in the chat. Again, on behalf of the Gold Group, thank you for spending your lunch hour with us, and we hope to see you at future CLEs. Thank you so much, everyone. Have a good day.
Thank you.